Hello, everyone, and welcome to Thursday Talks with Chug. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez from Chug Attorneys and CPAs, tuning in from our San Diego office. Please join me in welcoming partner and attorney Diya Mathews from our Edison, New Jersey office. Hi there, Diya. Welcome.
Hi, Ariana. Good to be here. Thank you.
Thank you so much for being here. Today, we're going to be answering all of your pressing questions on traveling as a non-US citizen. Before we begin, I'd like to remind you that this conversation is for informational purposes only and does not create an attorney-client relationship. So if you do have questions, please comment them below or email us anytime at info@juke.com. So let's start with the first things first, Dia. The latest travel ban that just came out yesterday, can you tell us what that is?
Yes, Ariana. And as we know, no Trump administration is complete without a travel ban. We had travel bans in the last round in 2017, primarily focused on Middle East and African countries. And so it's a version of the same this time. We have 12 countries that are now banned from entry into the US. And this includes Afghanistan, Chad, Haiti, Iran, Libya, Somalia, a couple of others. And then there's also 7 other countries which have restricted travel, from which restricted travel would be permitted. And this includes Cuba, Burundi, and a few others. It's important to note that the travel ban does not invalidate the visas that have already been issued. So what it talks about is it prohibits issuance of new visas, and it also does not apply to permanent residents, right? So those, people from these countries who are permanent residents of the US, they can still continue to travel. People with current visas can travel, and certain limited visas would also be issued to people from these countries. But overall, the travel ban is expected to go into effect on Monday as per the proclamation.
Thanks for clarifying that. With all of these updates, it's so important to stay on top of these changes. So looking ahead now, what can we expect with the next travel ban?
Well, with the travel ban, I think we expect that it would be challenged in court. But keep in mind that the last time we had the travel bans, they were ultimately upheld by the Supreme Court, because the Supreme Court they ruled in favor of the president, saying that ultimately the president has the executive has the authority to determine immigration policy, and travel bans fall squarely within that. So based on that, it would have to be seen how this plays out. A legal challenge is possible, but we'll have to see what the outcome is going to be.
Okay, that's helpful to know. So now for non-US citizens, what are some key things that they should check before making international travel plans?
Right. And so for today's discussion, Ariana, I think I'm going to assume that we are primarily going to be talking about people who are within the US and who might want to travel outside, right? Do some international travel and then plan on coming back. So for individuals in that category, the first thing is to know what visa status you are in the US, right? First understand, because you have to know whether are you in H status or H4 status? Are you an applicant for adjustment? And sometimes you can be both, right? You can be an H or an L visa holder with an application for adjustment pending. So it's important to determine what category, your current status actually is. And then make sure that you have the necessary documentation to re-enter the US if you are departing the US. Departing the US is usually not a problem, right? What matters is whether you have the ability to get back into the US, whether you can re-enter the US. And so a lot of it depends on knowing what your current visa status is. So perhaps we could take it from there. Maybe we can talk about specific visa categories and the applicable documentation for each.
Absolutely. Yeah, let's start with H-1B and L visa holders. What should they be mindful of?
H&L, yeah. So that's easy in a way. With H&L visas, you primarily need to look at whether you have an existing visa stamp in your passport. So also keep in mind that visa and approval are two different things, right? When immigration attorneys or immigration practitioners use the word visa, they're usually talking about the visa, the visa foil in your passport. And that is what matters for purposes of re-entry into the US. Once you enter the US, the visa stamp or the visa foil is not really relevant anymore, because you are then governed by your I-94. Each time you get into the country, you're given an I-94 by the CBP, and that indicates how long you're allowed to stay here. Anytime you need an extension of your authorization to stay here, you would file an application for extension, and then you get an approval notice. So that again allows you to continue staying in the US. When you exit the US after this, you have to see whether you have a valid visa stamp that would allow you to come back. If the previous visa that you had in your passport has expired, then you will need to apply for a new visa interview and get a new stamp and then come back. So, so anytime you exit the US as an H or L visa holder, if you don't have a valid visa stamp, then account for the fact that you would have to get the visa interview. And, obviously there is a little bit of uncertainty around that, because anytime you apply for a visa at the consulate, you could be refused. So that's what you should plan for.
Mm-hmm.
And in applying for these visas, there's a whole laundry list of documents that you will need, especially if it's employment based. So, you'll need the approval notice, probably some recent pay statements from your employer, and the whole, lot of documents based on the kind of visa category that you're applying in.
What about F1 visas? What should they be prepared for?
F1 visas or students, yes. So that's again another category that needs to be very, very mindful of the documentation requirements. Again, when a student typically comes in on an F1 visa, most consulates now issue the F1 visas for 5 years. Of course, it depends on reciprocity and things like that, but typically consulates would issue the F1 visas for 5 years. So when you come in as an F1 visa holder, you are allowed to stay here as long as you maintain valid student status. And so that's why your I-94 is, it denotes DS. That means that as long as you maintain your valid student status, you go to class, or, you're maintaining, you're doing everything that a student should be doing, you're fine. When you exit the US, there are a few things to keep in mind. And this is probably an exception to the rule that you can, pretty much depart the US anytime. Before F1 visa students depart the US, they should make sure that they have that their I-20, which is issued by the school when they're admitted, that the I-20 is signed by the DSO. The DSO is a designated school official who pretty much administers the student visa program for the university. So when an F1 visa holder exits the US, their I-20 should have the endorsement or the signature from the DSO, and that should not be more than 12 months old, right? So keep that in mind. If it's somebody on in the OPT status, so within F1, after you complete your program, the student would be eligible for OPT, optional practical curriculum training. And so if you are in that OPT period, then the signature from the DSO should be less than 6 months old. So those are a few things to be mindful of. And then when you come back in as an F1 visa holder, have sufficient documentation with you to show that you are actually maintaining F1 status. And what does that look like? For somebody who is in school, that would include, your transcripts, your proof that you're actually attending classes, along with the I-20, and the F1 visa stamp in the passport, of course. And for somebody who is in OPT, or in one of those EAD statuses, you have to have your EAD, the F1 OPT EAD, plus documentation to show that you are actually employed. So maybe an offer letter plus some recent pay statements.
Mm-hmm. Wonderful information there. Lastly, can you go into green card holders a little bit?
Yeah. So traveling green card holders. And we get this question a lot because, a lot of green card holders they choose to travel once they get their green card. Maybe they think they're a little more free to travel. So sometimes you'll have situations where green card holders would probably they might have been outside the US for an extended period of time. And that's where it gets tricky, right? Because once you get your green card, your permanent residence in the US, it's expected that you maintain your residence in the US, you are domiciled here, and you actually live here instead of just visiting the US, right? And so that's one of the things that CBP is trained to look for. They are trained to look at whether somebody is actually just using the green card to visit the US, or are they really living here, residing here. So if a green card holder is coming back within 6 months of exiting the US, then it's usually not a problem. They'll be admitted without too many issues, even if they're doing this fairly frequently. But the minute you cross 6 months, then it becomes a little different, because then it's almost like you're applying for admission again. And so CBP has more power at that point. So then they could question you on whether you're actually residing here, and whether you had a good reason to be outside the US. In general, the rule is that if you're outside the US for more than 12 months, then you're kind of presumed to have abandoned your residence. And then the burden of proof is on the applicant or the green card holder to show that they have not abandoned their residence. So it's always advisable to come back before being outside for 12 months, and actually to be very, very safe, come back before you hit 6 months. Because once you exceed 6 months outside, then you break the continuity of residence. And it also means that applying for citizenship, for naturalization, is going to be all the more challenging, because in order to be eligible for naturalization, one of the requirements is that you should have, there are two requirements. One is the physical presence, that you should have spent a certain number of time in the US in the 5 or 3 year period preceding your application. And the second requirement is that you should not have broken the continuity of residence by being outside the US for more than 6 months. So it's always better to come back within 6 months. Now, even for people who have the situation, generally the CBP is supposed to allow them entry into the US. They are not supposed to turn away permanent residents, right? So you'll have the situation that sometimes people get hassled at the airport when they come back in, if they've been outside for an extended period of time, or if the CBP officer makes a determination that they are not really living here, they're just visiting. Maybe they're working overseas and just trying to come here for holidays and things like that. So the one advice that I tell my clients is, never keep in mind that CBP cannot take away your green card. CBP does not have the power to make that determination, but they will often pressurize the traveler to surrender their green card. Like they'll say, here, sign this 407, and then we'll admit you in as a visitor, and you can finish this trip and go back. So never take that deal, right? You can, worst case, you go before a judge, an immigration judge, and then you explain what happened. But never give up your green card at the airport at the behest of CBP. There's also a memo, a CBP memo, which came out during COVID, and that clearly states that if somebody is presenting a facially valid permanent residence card, a green card, and the CBP is then supposed to admit you, and the airline is also not supposed to refuse you boarding. But sometimes it happens that when a permanent resident is coming in, maybe their green card has expired, right? And they might have filed an I-90, which is the application for renewal of the green card or extension of the green card. And, as long as they present both those, the expired green card as well as the I-90 receipt notice, they are supposed to be admitted. And these days, you'll also have the biometrics appointment notice going out usually, where you have to present your fingerprinting, fingerprints before the extension can be approved. So with those two, so with these documents, right, the expired green card, the I-90 receipt, plus the biometrics appointment notice, you should be allowed to board. But sometimes some airlines don't let you board. And so in that case, you should probably seek legal counsel or maybe try a different airline.
Wow, wonderful advice there. So, can you walk us through the process at CBP?
Yes. So when you come in at the airport, with visa holders, it's important to keep in mind that even though you have a visa in your passport, that does not guarantee you admission into the US. You are still applying for admission at the port of entry. And so that's why you have to go through this process of applying for admission, where the officer will examine your documents, sometimes ask you about the purpose of your trip, how long you're going to be there. And the officer then has the right to refuse admission. And this is a matter of national security, and oftentimes they have unfettered powers with refusing admission. So that is one category of people with the visa holders. With the green card holders, as I mentioned before, generally CBP has to admit you unless there is again a national security issue or something like that. But with green card holders, you generally cannot be refused admission. Citizens again have to be admitted, and so they cannot be sent back.
So that actually clears up a lot about the process. It sounds like being organized is crucial. So, what are the most common reasons non-US citizens are sent to secondary inspection? Do we have any information about that?
Yeah. So let's talk about secondary inspection, right? And what does secondary inspection mean? It's not necessarily a bad thing. It just means that you have to go through an enhanced inspection or admission process. It just is going to take more time than what you would normally expect at the counter. So with secondary inspection, if the CBP officer makes a determination that you have to go to secondary, then you'd be taken to a different room and you'd probably need to, you'd be made to wait there. And sometimes, this can make travelers very nervous because you're coming back after a long flight, and you have to wait, and you don't know how long you have to wait. It might take a few hours. Sometimes it's relatively quicker, but you could be waiting there for some time. And what CBP says is because they have to ping different databases and they have to examine and make sure that there is no risk with this traveler. So it just takes some time. It's not necessarily a bad thing. We see this often with people traveling on advance parole, because with the advance parole, which if you have an application for adjustment pending in the US and you are an advance parole um, holder, then there are certain databases that they have to check, and so you're just waiting while those databases they run their checks, and you're still waiting on that. So that takes some time. But other than that, there are certain situations in which you could be sent to secondary. And that could typically it is when there is some sort of discrepancy in the travel documents, maybe the names, the middle names, or maybe they see some mismatch in the dates, travel dates, or date of birth listed in the documentation, things like that. So that would be one case where they have to do secondary inspection. Or if they think that they want some more information about the person's purpose of visit, right? Whether they maybe they suspect that the traveler has the intent to overstay or maybe work in the US without authorization. So in that case, they might examine your devices, your cell phones, laptops, WhatsApp messages, to see what the intent is in coming to the US. And this also involves going to secondary. Then if there are previous immigration violations, right? So if you previously overstayed, even if it is just a few days, if there is any suspicion of unauthorized employment in the past or prior deportation orders, removal orders, which are still on the record, or if you were in some way flagged in immigration systems. And sometimes it could be for no fault of yours. It could be just that you have a name which kind of is similar to somebody else's, right, who has been flagged. And so all of these will result in secondary inspection. And then sometimes there's just, random checks, especially in these high traffic ports of entry. And they could also, be, clarifying that your status is actually what you're presenting it to be. So even if you present an approval or a visa which shows HL or one of those visas, they still need to verify it at the back end, and so those also would result in secondary inspection.
Mhm. Definitely good to know that those red flags can happen even with the smallest of inconsistencies. So if somebody were to get pulled aside or denied re-entry, what should they do in that moment?
Right. Yeah. So the important thing is to stay calm. And I know it's easy to say that, but usually they go through a whole process where they will um, interview you, ask you a number of questions, make sure that you don't have a claim to U.S. citizenship, etc. So there is CBP has a process for it. Now, it is a little intimidating, the whole process, but you don't really have, a traveler does not really have access to a lawyer. There's no right to an attorney at the port of entry when you are coming in. So if it looks like the interview or the questioning is not going well, and you feel like CBP is going to make an adverse inference, then what you can do is ask them to let you withdraw the application, right? So when you withdraw the application, you're allowed to go back without it really being prejudicial. So instead of expedited removal, it just says that you were allowed to withdraw the application. And the good thing with that is that it doesn't stop you from coming back again or applying for admission again in the future. They're not supposed to hold that against you, the fact that you are allowed to withdraw the application.
That sounds like a smart move to avoid the expedited removal process. So now, is it ever advisable to avoid international travel while certain applications are pending?
I, I've been practicing immigration now for a while, but and earlier I would tell people, hey, it doesn't matter, you can just travel. But now I think I take a little more conservative approach, and I tell them, once you're outside the US, obviously there is no control, right? Like you can't predict how whether you will be guaranteed admission. There's no guarantee of readmission unless you're a US citizen. So you have to bear that in mind when you make travel plans. Now, what are the specific situations in which you have to be extra careful? So if you're an applicant for adjustment, when you have an I-485 application pending with USCIS, that you should not travel without getting the advance parole, right? That's the basic rule. That if you travel when your adjustment application is pending without an advance parole, then the adjustment application is deemed to be abandoned. So so for most people it means waiting a certain period of time, because when you file the 485 application, you can do it along with the advance parole application. And these days the advance paroles are getting approved fairly quickly, I would say, in 3 to 4 months for most categories. But there were times when when the advance parole adjudication would take 12 months or more, right? And so it means that you're stuck here then until you get the advance parole. Now, the exception to that is people in H and L status. So H and L visa holders, H-1B and L visa holders can depart the US even when their 485 application is pending without having to wait for the advance parole, right? So it gets a little tricky explaining this to people sometimes. And I know of plenty of people who departed the US not knowing that their 485 application was going to be denied for abandonment because they travel without the advance parole. But again, if you are maintaining H&L status, then that forms an exception to the rule. And so you would be able to travel without abandoning the 485 application. But it's also a question of, let's say your visa, let's say you're a person in H or L status, and you're working here in that status and you feel it's safe for you to travel outside. But if you don't have an advance parole and you have to still apply for a visa stamp at the consulate, then there is always going to be that uncertainty around that, whether you will be issued the visa stamp, right? Because it's a fresh application at the consulate. And so again, we know of people who been stuck outside because they travel without the advance parole, and they couldn't secure the new visa, the new H or L visa as may be. So we can never tell somebody whether to travel or not. We can only just tell them about the consequences, and they have to make the decision on their own.
Thanks for that clarification. It's definitely a case-by-case situation. So finally, last question for you. Let's talk about search and seizure at the border. What rights do travelers have when it comes to CBP searching their devices?
Yeah, that's a big topic in itself, as you know, Ariana. And I think we should probably have another session just on that. But I guess the main rule is that CBP agents can search your belongings, including your phones, your laptops, at any point at the when you're arriving into the US, right? And they can do that without a warrant, and they don't need your consent really for it. This applies to all categories of travelers. It applies to citizens, green card holders, and visa holders. They can also ask you for your passwords, and you have to give them access to your systems, unless you're a US citizen, right? A US citizen can refuse to give, share these passwords, etc. And CBP will still not be able to refuse them entry. US citizens, as we know, they have to be let in at all times. But if a US citizen refuses to share password or give access to a device, then CBP can detain that device. They can take that away and examine it and then probably give it back later. So that's the only exception for US citizens. With all other categories, whether green card holder, citizen, visa holders, etc., if you don't answer their questions or give them the passwords or let them search your device, then you could be refused entry. So that's the distinction. And the advice to travelers generally would be to not have information on the devices that you don't want CBP to see, right? It's always preference. You should probably delete all unnecessary applications on your phone, like WhatsApp and things like that. You can reinstall them once you're back here, but if you don't want to necessarily be subjected to the search and seizure, then just delete everything and keep things on the cloud, because they can't usually access the cloud, but they can search your phones and laptops.
Absolutely wonderful insights today, Diya. Thank you so much for taking the time and giving us all of these wonderful insights. So that is all we have time for today. Thank you everybody for joining us. A special thank you to you, Diya. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If you have any questions or suggestions, please send us an email anytime at info@juke.com. Let us know what topic you want to see next, and make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care, everybody. Thank you. Thank you, Diya.
Thank you, Arianna.